Historic preservation laws, particularly local preservation ordinances, have faced some challenges in the past for being in violation of certain constitutional provisions. Fortunately for us, despite those challenges, preservation law has managed to remain relatively intact. And even though there have been some limitations placed on what it is we can do as preservationists, these challenges have helped us to understand where it is that preservation fits within the broader context of the law. There are a number of ways that constitutional issues come up in preservation law. In this course, I'm only going to talk at length about two: takings and religion. Takings come from the 5th and 14th Amendments. This is what I'm addressing in this unit. I'll also be talking about historic preservation of religious and sacred sites, which implicates the First Amendment, specifically the free exercise and free establishment clauses. You should also be aware, though, that preservation has made its way into court for other constitutional reasons as well. For example, in a First Amendment free speech claim. In Globe Newspaper Company v. Beacon Hill Architectural Commission, there was a challenge to the Boston Preservation Ordinance, specifically the part that banned placing newspaper distribution boxes on public streets in the Beacon Hill Historic District. There have also been questions raised in the preservation context about the exercise of congressional power. This comes up in one of the first U.S. preservation cases before the Supreme Court, in U.S. v. Gettysburg Electric Railway Company. This case questioned Congress's power to create a law allowing for the use of eminent domain to take the Gettysburg battlefield land and to prevent the Electric Railway Company from running trolleys on the property. There are also due process questions that come up in preservation. Due process has to do with how the law is administered to ensure that it's administered fairly. This comes up in a case called Mayer v. City of New Orleans. In Mayer, the plaintiff complained about process. He brought an action against the City of New Orleans when he wasn't able to get a permit to tear down a building on his property because the structure was protected by the local preservation ordinance. Mayer claimed that the ordinance violated due process because the Preservation Commission hadn't established objective criteria to base its decisions on. You'll actually read the Gettysburg and Mayer cases in this unit because they also speak to the takings issue. But be aware that there are many other ways that constitutional claims can pop up, and oftentimes they pop up in the same cases. In regard to takings, the amendments that you need to consider are the 5th, which include the takings clause. I already mentioned this in the introduction. Remember those 12 simple words? Nor shall private property be taken for public use without just compensation. This is where federal actions are covered. And also the 14th Amendment, which is the due process clause. This is how the 5th Amendment applies to the states. In fact, most of the provisions of the Bill of Rights apply to the states through the 14th Amendment under the doctrine of incorporation. So again, takings come to us through the 5th Amendment takings clause, and to the states through the 14th Amendment and incorporation. It's important for you to understand up front that there's nothing in the Constitution that prohibits the government from taking private property. There are, however, limitations, and that's what you'll learn about in this unit. There are two types of takings that I'm going to talk about. There are condemnation proceedings, which are using eminent domain and where the government admits that there's a taking. And then there are regulatory or constructive takings, where the government overregulates a property to the point that it rises to the level of a taking. I'm going to talk about eminent domain first.
My home is not for sale, and if my home isn't safe, nobody's home is safe.
What Jim Salete is talking about is the city of Lakewood, Ohio, taking his house, his home, through eminent domain to make way for a high-priced condo that will pay the city more in taxes than he and his wife Joanne do. And he says he's not going to take it lying down.
It's a close-knit, beautiful neighborhood. It's what America's all about. And I'm going to fight them tooth and nail. I've just begun to fight.
Eminent domain is sometimes helpful and sometimes extremely contentious as a tool that governments can use to seize private property for public use. The government can and does acquire property through what you might call a normal sale, something like a transaction would be between you and me, with an agreed upon purchase between two parties. The government would make an offer to a willing seller for an agreed upon price. But sometimes a property owner doesn't want to sell, or sometimes there isn't a meeting of the minds on price. When this happens, the government may resort to using eminent domain, taking the property against the owner's wishes, albeit to be used for the public good and after paying just compensation. The calculation of just compensation is outside the scope of most constitutional law classes and certainly this survey of law class. But what you need to know about just compensation is that it's intended to be the fair market value of the property. There are often disagreements about what fair market value is, and expert testimony and argument is important to that determination, but again, it's a bit beyond what you need to know for this class. The federal power to exercise eminent domain is not one that's expressly given to Congress. It isn't what's called an enumerated power. Simply put, there's nothing in the Constitution that specifically says, hey government, take what you want as long as you pay for it. Eminent domain actually comes from what's known as the necessary and proper clause. And this comes from Article 1, Section 8, Clause 18 of the Constitution. It's also called the elastic clause, or sometimes the basket clause. It states that Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution powers vested by this Constitution. For example, the federal government can use the power of eminent domain to take land to build a post office because it's necessary and proper for the government to provide a post office, or a road, or maybe even a national park. For states, and therefore local governments as well, the justification or authority comes from the police power, which is from the 10th Amendment. This allows the use of eminent domain or takings for the public health, safety, and welfare. When the government decides to exercise its power of eminent domain, it initiates what's known as a condemnation proceeding or condemnation action in court. Generally, when the government wants a piece of property, it goes to a property owner and makes an offer to buy it. If that offer is not accepted for whatever reason, the government initiates this process. This is essentially the government acknowledging that the property is being taken or condemned. And that's not to be confused with when a property is condemned for health reasons. And then the government begins the process of determining how much compensation is due. There are several reasons that a government might initiate condemnation proceedings. For example, you could have a situation where the seller is unwilling to sell at any price. Or it might be that the government and the landowner can't agree on a price. There might be defects of title of a property that prevent the landowner from conveying a clear title. There are also situations where landowners are missing or unidentifiable. This can happen in places where there are a lot of abandoned buildings, and this has actually been used as a justification for urban renewal in some situations. You may also notice in recent headlines that eminent domain has been used as a tool to deal with housing issues in areas where there are a lot of foreclosures. Take a look at this California example.
I want to turn now to how Richmond, California is tackling its foreclosure crisis. Almost half the city's residential mortgage holders are underwater. In a major development last week, Richmond became the first city in the country to offer to purchase mortgages of distressed homeowners from Wall Street banks and other lenders. Under a plan approved by the Richmond City Council in April, Richmond can also use its eminent domain authority to purchase loans in order to modify them and allow families to avoid foreclosure and stay in their homes. Other cities are advancing similar bills, like Newark, New Jersey and here in New York City. Well, Richmond Mayor Gail McLaughlin, who's a member of the Green Party, remains with us now from Berkeley, California, to discuss this new way of addressing the foreclosure crisis. Lay it out for us, Mayor McLaughlin.
Yes, of course. First of all, the housing crisis in Richmond is not over, far so from being over. We had 900 foreclosures last year and just as many in the pipeline this year. So this situation is something that we feel in the city of Richmond we have to address. It's destabilizing our families, it's destabilized neighborhoods, and it's caused a huge impact to the city as a whole. So the city is stepping in to fix this situation. The banks sold our community predatory loans, and now they have no solution that they're presenting for this crisis. So we are stepping in to fix this situation. We're stepping in by taking these troubled loans off the hands of the banks, and we're paying them fair market value for these loans. And then we're working with the homeowners to refinance and modify loans in line with current home values. So we call on the banks to voluntarily sell us these loans, and if they don't cooperate, we will be considering eminent domain. Again, paying them fair market value for these mortgages.
In the context of historic preservation, eminent domain has been used to set aside land for national monuments and national parks, and it's been used for other heritage conservation issues as well. Please continue with this section on eminent domain.